Thank you.
SJC-11350, Commonwealth versus Hanright.
May it please the Court. Fawn Bolero, Assistant District Attorney from Middlesex on behalf of the Commonwealth. And with me today is Assistant District Attorney Marion Ryan, who is the trial prosecutor in this case. The expert's review of the records relating to the diagnosis or treatment of the defendant's mental or emotional condition is part and parcel of the Rule 14b2 examination. These experts are tasked with the responsibility to form an opinion about the defendant's mental state at the time of the crime, specifically whether the defendant, as a result of a mental disease or defect or impairment, lacked substantial capacity either to appreciate the wrongfulness of his conduct or to conform his conduct with the requirements of the law. It's the defendant's position here that he only has a responsibility to pick and choose whichever records he thinks his expert needs to form that opinion. And then further, that information is only relayed to the Commonwealth at the point in time when the defense expert's report is disclosed.
Let me ask you a question about what can happen during the examination of the defendant by the expert witness. Is there any limit on the kind of questions that the expert could ask the defendant, or in bringing out his statements about his prior history?
This is a very important point. There's no limit on the Rule 14b2 examiner's questioning of the defendant during the examination or the material to be covered. The only limit to the waiver has to do with timing.
Right, but that's a big one, because it may be that it will never be disclosed.
That's right, and that's the protection in place here.
So I guess if it were to be the case that the defendant tells the Commonwealth's expert a list of treatment providers, and at the time of trial or right before trial, when there's this disclosure of the expert's reports, it becomes clear that the defendant's expert has, when he or she relates the history, isn't giving the same treatment history as may have been provided to the Commonwealth's expert. At that point, the Commonwealth can use that, one would think, to cross-examine the defense expert at trial about the very things you are worried about, the truth-seeking function, that not everything was disclosed to that expert, the expert didn't have full access to the treatment history and so forth. But the difference is, I don't really understand how it wouldn't the Commonwealth, on your request, wouldn't the Commonwealth itself, not just its expert, have access now to the list of treatment providers?
That's potentially true.
And that's not something that you would otherwise have.
That's also potentially true. So the real reason we're here today is because the Commonwealth believes that the Rule B2 examination should include a review of the treatment records. The question is how to get those treatment records to the Commonwealth examiner during this pretrial examination in order for it to be meaningful and complete and informed on behalf of that examiner.
Your solution to that is?
The way that it has been done traditionally is that the Commonwealth, at the time when they're seeking this examination, asks for a general ordering the defendant to disclose the any treatment provider maintaining these documents. And that was typically done. The defendant would then, the judge would order it. The defendant would go to the clerk's office and give a list of those providers to the clerk's office. The clerk's office would summons the reports to be delivered to the clerk's office under seal. And at that point, the judge could look at the records to determine what, if any, should be disclosed to the Commonwealth expert. The only problem with this is,
Are you saying this is the way it works now?
no, that's the way it worked before Schlickbroder, when defendants then started.
When you say it worked, that's what you anecdotally understand to have been the case in some Middlesex County cases?
That is correct, anecdotally. The Commonwealth is now proffering a new solution. The Commonwealth is saying that the list should be provided to both parties because it's not privileged material. When the defendant is putting his mental state at issue, he is giving up certain rights to produce evidence. And there's nothing privileged with the mere list of the treatment providers. There's nothing in there that's testimonial. There's nothing communicative. There's nothing that bears on his state of mind or his thought process. So he should give it to both parties, and that is the best way to be able to make sure that the.
But then the Commonwealth can, if I understand this correctly, can then, I take it at the point when defendant files his affidavit or whatever, saying I'm going to have this expert and it's going to rely on statements or may rely on statements, but hasn't decided yet whether he's actually going to call him. But the Commonwealth seeks to have an expert examine. So if that's allowed, obviously the report goes and is sealed, right? But you're saying at the point that the Commonwealth seeks to have the appointment of an expert, that's when the defendant should be required to provide the list of treatment providers to the Commonwealth, not right to the not under seal, just to the Commonwealth, right?
In my brief,
so even if no expert testifies, you've got those records. Is that what you're saying?
the Commonwealth, in its brief, proffers either doing it that way, directly to the Commonwealth, so that both parties are in a position to argue which documents should be produced, or to the court in an ex parte fashion, and let the court figure out which documents should be produced. Really, the only thing that is not privileged with regard to these records would be any of the defendant's statements about the crime or his mental condition through a compelled examination of him.
Well, you say that, but the psychological records themselves are within the psychotherapist patient privilege, and the judge would have to make a finding that the balance of interests favor disclosure over the protection of the privacy interest. How can a judge do that before the defendant has committed to pursuing an insanity defense or a...
The judge is in the position at that point in time to assume that the waiver is in effect, because this examination is being conducted under that assumption that the defendant has fully waived his right to self-examination.
No, it's a partial waiver. He's waived it to the extent that he's compelled to speak to the Commonwealth's expert, but there's essentially use immunity there, because the Commonwealth's expert is not permitted to disclose it to the Commonwealth, and the Commonwealth can't use it until the defendant actually decides he's going to proceed with that defense.
The waiver, the way that I see it, is not that he's only waiving his right to an interview. It's more than that. It's that interview is treated in the same way as if the defendant himself took the stand. If the defendant himself took the stand, he would be opening up the door to all of this information, and that's why the judge should be in the position, acting under the assumption at that point in time, to say that the defendant's rights against self-incrimination were waived, to make this a meaningful examination for purposes of rebuttal. This can only be used for purposes of rebuttal. I think that's an important point. Anything learned directly or indirectly through this examination can only be presented once the defendant himself puts in evidence of mental impairment at trial.
How do other states deal with this issue?
I did not find anything on point as to how other
But the
states
federal
are dealing with
government,
this. There's nothing with regard to...
the federal government has rules precisely on this point, so...
Right, but they don't talk about the pretrial disclosure of the defendant's mental
History.
Mental history, or actually the records,
Well, it seems,
how to get them.
I mean, it seems to me that what you're suggesting is reasonable in one respect, and that is that once the defendant has placed the court and the Commonwealth on notice that they intend to call an expert and intend to put their mental state at issue, that obviously an expert needs to be appointed by the court. And in order for that expert to prepare a sufficient report, the expert needs to have access to the treatment records of the individual. All of that makes sense. The problem for me is, how does one do this and keep it out of the hands of the Commonwealth? Because once the Commonwealth knows the list of providers, then the Commonwealth might use that for other discovery purposes or for other purposes in connection with its case. So is the solution here everything is sort of done under seal and in the judge's lobby? And
It's hard for me to imagine a situation where the mere list of treatment providers gives the Commonwealth any leads to further their case against the defendant with regard to the
Aren't you
the elements of the
suggesting, though,
crime.
that the Commonwealth can call up that provider, and if the provider happens to talk to the Commonwealth, so be it? You'd be entitled to do that? Don't you suggest that?
I don't think that would be a fair use of the evidence. The real reason for the Commonwealth obtaining this information is to make sure that the treatment records and the proper treatment records are put in the hands of the expert, so that that expert's opinion is fully informed and also admissible at trial in rebuttal. So we just want to make sure they're getting the right stuff.
So can't a court order be fashioned that prevents the Commonwealth's psychiatrist from disclosing any information that's contained in any of those reports pending a court order?
I would assume that they could do that. That's a
Do you
possibility.
object to that?
There would be no objection to that, where the only reason this becomes relevant is because the defendant himself is putting his mental impairment at issue.
You want to get all of this information to the Commonwealth psychiatrist so that the Commonwealth psychiatrist can conduct a medically proficient and competent interview and examination of the defendant for purposes of giving an opinion.
That's correct. So in these situations, the investigation is done, charges have issued. There's no means other than consent to getting the record information from the mental health providers. So it makes sense that if they were willing to talk to us, to that extent, we should be precluded from contacting them in conjunction with finding out about the defendant's mental condition at the time of the crime.
Now, isn't there an easier alternative, which is simply to say that the defendant has to provide the Commonwealth's expert with whatever treatment records it furnishes the defense expert?
Well, that puts the defendant in the position to be able to cherry pick which records he's providing to the examiners, which is the Commonwealth's position that Rule 14b-2 says that the defendant has to fully discuss his treatment history with the expert, or vice versa. The expert has to fully discuss it with the defendant. So it's a foregone conclusion that everything should come out during this examination, and the defendant should...
But doesn't the defense counsel risk being found ineffective if the defense counsel is withholding from the defense expert information which may be relevant to...
Not necessarily, because the relevant mental health records could be, the defendant's proclivity
to violence?
Yes, to violence or to lie, to malinger, to those types of things, and he would not be found ineffective for failing to provide that. What he'd really be doing is in direct contradiction with the truth-seeking purpose of this examination.
Okay, but you know that in Slate Brodeur I lost on the issue with respect to the question of whether or not cherry-picking is to be a problem.
But that was more in the context of the work product information, not the foundational information that is necessary for the expert to form the opinion. This was in Schlick-Broder, all that was at issue in my view was the work product that the notes and of that examination.
The statements of the defendant.
And the statements of the defendant. And where the Commonwealth's entitled to its own interview, perhaps the statements won't be the same. But that is what we're stuck with at this point in time.
thank you.
If there are no further questions, I'll rest on my brief.
May it please the court, John Osler for Scott Hanright.
Why isn't it perfectly reasonable and very consistent with the whole purpose of the rule for the Commonwealth's expert to get this information?
Well, the Commonwealth has vast investigative resources, and it may be that they would get the information. I think the question is whether the defendant can be required basically to provide the Commonwealth with the names of witnesses who could then come in and testify against them.
Well, let me ask you, when you say provide the Commonwealth, are you referring to the Commonwealth, or are you referring to the Commonwealth's expert? Because I see those as presenting two quite distinct sets of issues.
Well, I certainly think that the defendant would answer questions by the Commonwealth's expert, which might include places he recalls having been treated. I don't think that.
But I mean, I think what was one proposition was that the list of treatment providers be provided to the designated expert for the Commonwealth, not to the Commonwealth, and it wouldn't be revealed to the Commonwealth until quite a bit later point in time.
Well, I think that's outside the scope of the limited waiver that's been recognized so far in Blaisdell, and I don't think it's provided for in the rule. And I do think that there are self-incrimination problems with the defendant having to provide a list of anything, which is going to be a list of evidence that the Commonwealth ultimately could use against him.
Now isn't there a problem, though, if there were to be a defense expert who says, I find this defendant not to be criminally responsible, and I base my finding in large part on the fact that when he was in the Army in Oklahoma, he was found to be schizophrenic. There were many findings with regard to schizophrenia from a hospital in Oklahoma. He lived for a time in Nevada, and there were findings there of schizophrenia. And then in closing argument, the defense counsel says, well, the Commonwealth's expert found him to be capable of knowing what he was doing, but of course he didn't even look at those treatment records. He didn't have access to those records. He didn't even know about these findings. How is that fair?
Well, I don't think the Commonwealth's expert in the end would be devoid of knowledge of what the defense expert relied on, and now the practice has always been that the defense experts.
Why is that? They would learn it at the same time. The reports would come out together.
So, and then is there a re-exam by the Commonwealth's expert?
I don't think there would be a re-exam, but it's certainly not uncommon to ask an expert whether, if you had this information and that information and the other information, would it change your opinion?
Well, if it ultimately gets to, if the Commonwealth's expert ultimately gets to see this, when would that happen? I mean, would it be after the defense psychiatrist testified and disclosed all this information? And then we postpone the trial for 3 or 4 days or longer?
I think it would happen at the point that the reports were released, that the Commonwealth examiner's report was released, and then the defendant would be producing at the same time the report of his expert.
So the Commonwealth's expert has already produced his report or her report based on incomplete information about the treatment history. That doesn't make a lot of sense under the rule.
I think it's interesting that, and as far as I know, there is none. The Commonwealth has not been able to point to a single American jurisdiction that provides this kind of discovery, although they say that it's necessary.
Are you able to point to any which say that it's not required?
No, and it's clearly not available under the federal rules of criminal procedure.
Not available pursuant to the rule, or not available? I mean, is there any court case which has said no, they don't get it?
What about the practical, before Slice-Brodeur, Ms. Anderson says the practice was as she described. Is that do you have a different view of what the practice was?
Well, I think the practice varies. Certainly there are cases where the defense lawyer simply gathers up the records and sends them to the government's expert. Not in all cases, and I didn't choose to do that in this case. So I don't know that there was a consistent practice in every case. I think it varied a lot. Sometimes it isn't turned over right away, but maybe there's discussions about plea negotiation or something, and it makes sense to turn it over then. And certainly, the expert mental health testimony is like any other evidence. It's subject to adversary control. It's not some kind of a separate category where the advocates don't make the decisions about what they're going to put into play. As I think Justice Gantz pointed out, there's there are a lot of practical and strategic reasons not to withhold anything from one's own expert. But the question here is whether the defendant has that right to make a decision about what he's going to put into play. And even if the information is turned over to the expert, it isn't necessarily going to be relied upon or used by him. The expert can look at some of the records or talk to some of the treatment providers and say, well, this is way off base.
But that's a question for cross-examination, isn't it? Whether or not an expert found it, judgmentally appropriate to not even consider certain potentially incredibly damaging material.
Yes, I think that's fair game for cross-examination. I think that's one of the reasons why, as a practical matter, in most cases, I think that the defense attorneys turn over all the records that they have and all the information they have to their expert. But I don't think that it follows from that the defendant should be required to provide this information. And certainly our rule does not provide for that.
So, and isn't it fair game for a defense counsel to cross-examine the Commonwealth's expert and ask that expert whether or not it would be his routine practice clinically to examine all treatment records before he makes this kind of conclusion, and then to point out that he did not do that here?
Well, I don't think we could get to that point in a trial without all the records being available.
So you're saying that
basically what we're talking about here is pre-trial discovery.
Are you saying then that before the Commonwealth's expert would testify, he would have access to all those records?
I think they would. They'd certainly see what was relied upon by the defense expert. The reports are now mandatory under the new rule.
So he would see more than the report. He would then see the actual records?
In my experience, they do, but I don't know that the rule does not provide for that either. This rule,
right? Well, that's why we're here.
But then he'd only see whatever it was that the defendant's expert saw.
Relied upon, yeah.
Or relied upon.
Right.
So not even what the defense expert saw, just what the defense expert relied upon.
Under the rule, the way I read the report writing requirement, it would be what the defense experts relied upon.
So it would have to be that the Commonwealth's expert would be limited to before testifying.
It would be unless the Commonwealth's expert, perhaps based on her own examination of the defendant, thought that there was more out there that should come into play. The court said in Schleck-Bruder even that at trial, the trial judge, if asked, could order an expert who seemed to be cherry-picking to disclose more of his information and the things that he had seen.
Let me ask you, I don't think it relates directly to this, but there's this showing of necessity, the argument that you make. And I guess my question is, how would you envision that ever working? I mean, because how would the Commonwealth know? I mean, if it's expert in interviewing the defendant, learns that there are all these medical treatment records out there, he or she cannot tell the Commonwealth that that's what the expert has learned. And even if the expert just is eager to have access to these treatment records, they can't disclose that to the Commonwealth so that the Commonwealth can come in and ask that they be provided, right? I mean, so how is it...
Well, at the point that the evidence is coming in at trial...
No, I don't mean at trial. I mean before trial. And that's what I see this as being, a before trial sort of showing of necessity.
And at that point, if that was to happen, it seems that the Commonwealth would have a lot of cross-examination material for the defendant's expert.
Which they could use at trial.
Yes.
But and I'm asking for the discovery aspect of this. How could the Commonwealth show necessity? You're saying here they didn't. I'm asking you how they could.
Well, I don't. The way I read the rule, it certainly wouldn't cover the kind of request that the Commonwealth has made here, because the discretionary discovery provision that was added to the rule, it says it's upon a showing of necessity, and in the reporter's notes it says it's got to be things that are completely out of the ordinary. It's going to be rarely used, limited grant of discretion. So the arguments that the Commonwealth makes here and they say this in their brief, are arguments to make this happen in every case. It would be part of a mandatory disclosure when the notice is given under paragraph A.
So you're saying it has to happen under the rest of the statute the rest of the rule. It can't rely on the discretionary provision of the rule.
Well, it doesn't look like, and the rest of the rule certainly doesn't provide for this. It's very explicit about what the defendant has to give notice of, and it doesn't include his treatment history. So I don't think there's any provision in the rule for the Commonwealth to compel the production of these records or the.
But a history of mental illness is oftentimes a key component in an insanity defense. I mean, we've even commented on that in our instructions. Or in our decisions, and we've even granted 33E relief because defendants have had significant histories of mental illness.
I think the question is how does the history get taken? You know, the rule makes a reference to, now the new rule, to the report including a summary of the expert's testimony, including a number of things, including history. And the Commonwealth's position is that somehow encompasses all of his treatment records and treatment places. But in Blaisdell, the court directly addressed the question of what the psychiatric interview would involve, and it appears at pages 759 to 760 of the opinion, and says that the primary diagnostic source is the nature and content of the defendant's statements, and goes on to mention that the defendant will be called upon to recite his life history and his emotions and his feelings. I think a clinical taking of a history is what the clinician gets by talking to the client. I think that's what the primary source of it is. So, and certainly there are, as a practical matter, there are plenty of situations where even responsibility evaluations are done, and this rule is not limited to lack of responsibility defense as it applies to any intention to offer expert testimony on the defendant's mental state. There's certainly plenty of situations where the responsibility evaluation is done under 15A and even sometimes under 15B where they never get records of the previous treatment. Either the evaluation is done at Bridgewater and they've ordered the records and they didn't arrive before the evaluation period was up, or it was done in the courthouse and nobody even asked for them.
Of course, one of the problems is that if a defendant does not disclose a full history with providers to his or her own psychiatrist or psychologist, and then come time when the Commonwealth psychiatrist examines the person and they get the complete list through an interview with the defendant, then the defendant's psychiatrist looks like a fool for not having even been able to get the complete history.
Right. I mean, I'm not advocating that the defendant should hold back, or defense attorneys should hold back the records from their own experts. I'm advocating that the defendant has a self-incrimination right, not be required to provide.
What is the vehicle? The defendant's being interviewed by the Commonwealth's expert who says, tell me all the persons who have treated you, and the person goes through a lengthy history. Mm-hmm. How can he get those records? How can a Commonwealth expert obtain them? He doesn't have subpoena power. He can't ask the prosecutor to get them for him. How is he supposed to get them?
The way I read the rule, there is no way for them to get them. Now, as a point that the reports are exchanged and the experts are able to talk, the Commonwealth's expert is able to talk to the prosecutor, and if it seemed like there was a need for it, the prosecutor at that point, I assume, could move for it, maybe make a showing, even under Rule 17.
Okay, but that could be during trial.
It could be during trial or toward the beginning of the trial or just before trial.
Then, well, I mean, as a practical matter, that's not going to work. You know how long it
It's not
can
going
get
to work
to
in
get
those cases
records.
in which the final decision isn't made until the government has rested its case, but I think, correct.
Well, I'm just thinking as a practical matter, at least in my experience, getting records is no easy matter on a speedy basis.
Yeah, and it doesn't make for good opening statements, for either lawyer. When we don't really know what the expert testimony is going to be, isn't this something that is a practical matter, just for the administration of justice, for the administration of cases? This is something that should be done well before the case is tried.
Well, I think what the Commonwealth wants you to do is amend the rule again. And I think really all I can tell you is I don't think the rule provides for it as it is presently written and as it was recently amended. And I think that to the extent that it requires the defendant to disclose to the Commonwealth any evidence other than that he already intends to use at trial, it violates his self-incrimination right. It runs out from under the cover of the accelerated disclosure doctrine.
And why would that be if again, put aside the Commonwealth's theory, if all he had to do was to give to the Commonwealth's expert the same records it gives its own expert, and then those would still be held by the Commonwealth's expert, would not even be disclosed necessarily to the prosecutor, at least until the defendant decided to testify or decided to invoke that defense, and the judge said that the Commonwealth gets those records.
Well, the request here is not for the defendant to disclose what records he's given to his expert. It's for the defendant to disclose his entire medical and psychiatric treatment history, whether or not he's given them to his expert. I think that at the point that the request is for the information given to the defendant's own expert, then the problem is not self-incrimination. There's a problem about attorney-client and work product and disclosing what basically the communication is between the lawyer and the client on one side and the expert on the other. I think there's a separate set of problems with that. And I think that the only stage at which there are no such problems is at which the Commonwealth is able to gain access to the materials on which the expert relies. Forming his opinions.
Mr. Osler, just one quick question from a practical point of view. Supposing these records, or some of these records anyway, contain a lot of fairly, I don't know if it's necessarily incriminatory information, but information in which the defendant had been fixated on a victim for a fairly long period of time and said certain things.
It's the OJ example. I dreamed about killing Nicole.
Yeah. How do we deal with that as a practical matter? Should defense lawyer bring that to the judge's attention? Should judges have to go through all these files and highlight this material and redact it?
Well, I think if we're talking about pretrial discovery, it seems it would have to be quite a bit of redacting. If we're talking about the point at which the defendant has decided, with all the pros and cons, to go ahead and put his witness on and put these things into play, then I don't see that they should be redacted.
Well, counsel, thank you. We'll leave it there.
Thank you.
We'll take a brief recess.